Well, welcome everyone. We've got another one of our scheduled webcasts today, and the topic is kind of the top estate planning myths. Hopefully everybody finds this a useful exercise. I'm attorney Peter Harbach.
I'm attorney Sarah Cons.
And we're from Hooper Law Office, located in northeastern Wisconsin. Okay, well, let's just jump right into it. We get a lot of myths that we hear about when we're dealing with estate planning. People come in and they think, oh, this is how estate planning works, or that's how estate planning works. And, by and large, we hear a lot of the same things over and over again. Sometimes they're sort of goofy myths that aren't grounded in fact. And sometimes it's just minor misunderstandings. And so we're going to go through some of the most common stuff that we hear to make sure that, everybody, we dispel some of the myths for everybody that might really affect how you're thinking about your planning. We should also mention that if you're on the Zoom webinar, you can post questions that we're going to address later before the end of the session. So if you have any questions, feel free to just type them in. If you're watching on Facebook Live, there's not really a way to submit questions. Also, for all of the people who've registered, we have a handout here that will get emailed to you of some of the top estate planning myths that we've come up with, which is going to be some of the content of what we're talking today, but we also have a tendency to meander a little bit into certain things. So number one of the most common things that we hear is, boy, the size of my estate is the most important factor in how I'm going to design a plan. And that's just not necessarily the case. Now, there's certain things that you would want to do, if you had a taxable estate, for instance, and a taxable estate means you have in excess of about $11.5 million per person. So for a married couple, around $23 million, and for a single person, about 11.5. There's certain things that you almost certainly would want to do in order to reduce the exposure to the estate tax, because that can be a 40% tax on the estate when somebody passes away. That's not really going to so much be the focus, because that applies to less than 0.2% of the population. So we're going to talk more about some of the other practical matters. Now,
when it comes to the size of the estate plan as well, probably one of the most common things I hear people saying regarding trust-based planning is, I don't need a trust because of the amount of money I have, which is exactly what factors into this as well. The size of your estate shouldn't dictate the type of planning that you're doing.
Yeah, so some of that's grounded in the fact that, 50 years ago, trusts were generally tools for wealthy people. The Rockefellers, Kennedys, families like that would have trusts. But as time went on, the estate tax that I mentioned is now $11.5 million coupon per person. In the 90s, it was very modest. People had an estate tax issue if they had, for some of the years, 600,000, some of the years 650,000 in total assets. And that included everything: the house, the bank accounts, the IRA, the life insurance proceeds. I mean, everything factored into that $650,000 mark. So that's where trusts became a very popular planning tool, because there was a way to more or less double the coupon for married couples so that they could effectively pass, closer to 1.3 million without having to pay any kind of estate tax. And the estate tax rate back then was up to 55%. So there was a very motivating tax reason for people to do a lot of trust-based planning. Well, as the coupons went away, the popularity of trust-based planning didn't, because in the 90s, a lot of law developed on all the different uses for trusts, passing assets outside of the probate court, setting up protection for beneficiaries, keeping things more private. So a lot of those secondary benefits outside of the estate tax remain, even though the estate tax issue hasn't so much been, the motivation for doing the planning. So if you're ever reading something that says, oh, if you have X number of dollars, you need to do a will, or X number of dollars, you need to do a trust, that's just some kind of fake marketing by whatever attorney's trying to hook you in. It's really more focused on exactly what your particular situation is, the composition of your assets, and then what you're hoping to accomplish for the family. That's going to dictate what the best tool is. So that also means that if your experience when you were doing estate planning was not talking to the lawyer about everything that you own and the situation for all of your loved ones or beneficiaries and what you're trying to accomplish, if it was just, give me the names, I'll put them into the will or put them into the trust, you haven't actually done any estate planning. You've had somebody just write some things down on your behalf, but that's not what estate planning is. The attorney absolutely has to understand the composition of all of the assets, because either of us would give incredibly different advice if somebody has a lot of money tied up in, say, farmland versus a lot of money sitting in an IRA or 401k, because there's completely different tax considerations on how you're going to plan that kind of estate. So again, if you only told people, oh, these are the names of my beneficiaries, put them into the will, again, that's just not an estate plan.
This also highlights the importance of making sure, if you're looking at something online or if you're reading something that you've come across, make sure that you look and see when it was printed or when it was written, what date is on it, and what it's specifically for, if there's like a certain area. So if you are looking for something regarding Medicaid, make sure you're looking at Wisconsin. If you're reading something regarding Medi-Cal, that's sort of California's version of Medicaid. If you're reading something that was prior to 2014, even if it's Wisconsin specific, there were a lot of changes that happened in Wisconsin in 2014, and both with elder law types of planning and with just estate planning. So you have to be careful where you're getting your information from. Make sure that you're looking at how recent it is, the audience that it's directed for. Make sure you're looking at something that's specifically for you if you're trying to better educate yourself on your options.
Okay, well, another one I know I hear a lot is, hey, I can avoid probate if I have a trust, but then end up putting all of the assets in the trust through a pour over will. I mean, I've even read that on attorneys' websites before. Oh, let's have a pour over will, but then we can avoid probate. How does that actually work?
Well, the idea of wills avoiding probate is, I think, kind of a wider spread myth in and of itself. If you have a will or you're using a will, it means that you're directing assets through probate. When you have a pour over will as part of your plan, if you have a trust-based plan, what you're using a will for in that circumstance is to kind of catch the things that maybe didn't get in your trust or didn't get designated correctly. Sometimes when people buy new property or open new accounts, they forget about making sure to direct it through their trust or putting the name of their trust onto it. So a pour over will is really more of a backup plan. It's not intended to fund everything into your trust under normal circumstances. So if you are using your pour over will to funnel assets into your trust after your death, it means that all of the assets going through your will have to go through probate first in order to then get into your trust, and then your trust gets administered. So a lot of the times when we're doing trust-based planning, one of the benefits that the client is looking for is the ability to avoid probate. Well, if you're using your pour over will to get everything you own into your trust, that means you're using probate to fund everything that you own into your trust. So that one priority in your planning is getting completely missed. You want to make sure if you're using a trust-based plan, you have things named correctly and designated correctly. The attorney that you worked with, if you worked with an attorney, should have talked to you about how you own things, directing things. When we set up plans for our clients, we go through and fund all of their assets for them, getting written verifications for each account that they have or each piece of property that they have, because we're trying to help them avoid having to use a pour over will to get anything that they own into their trust later. It's supposed to be a backup plan.
Yeah, I mean, we would still always draft a pour over will as the catch-all. But you don't want to rely on it. I kind of joke to a lot of my clients that I'm going to write this pour over will, and if the plan is successful, this is going to have been a waste of my time. We want this to be a waste of my time. because we don't want to have to rely on it. Just like, it's belt and suspenders planning. If you really don't want your pants to fall down, you might put both on, and you hope
one of them works.
Exactly. So another common myth, giving assets away to the kids is the best way to protect for long-term care. Hey, I should just transfer assets to my beneficiaries, my loved ones, my kids, whoever it is that I would want to ultimately receive them, because I don't want the nursing home to eat it all up.
We do hear that one quite a bit. And we have one of our earlier sessions, we talked a lot about the house in particular, the idea of gifting your house to your kids being part of your elder law planning. So it's something that you should go back and take a look at if this is of particular interest to you. But in general, assets getting gifted to whether it's children or other loved ones, with your intention being to protect them from nursing homes, you're subjecting it potentially to risks that they might have.
Mm-hmm.
Just because it goes from you to them, it doesn't mean it's completely safe. You're doing this for one risk that you think you might have, which is the idea of long-term care expenses. The person you gift it to may have things that happen to them. They could need care themselves. They could get divorced. They could get sued. They could get in a car accident. They could have creditor problems, medical expenses. I mean, the number one reason for divorce right now, the number one reason for bankruptcy right now is medical expenses. So you have all of these things that can happen to people over the course of their lives, sometimes not based on anything that they're choosing to do themselves. It's just sometimes bad things happen to people. If you're relying on that person to continue to safeguard whatever asset you've given to them, especially in the hope that it would be available to you to get back if you needed it later, it puts you in a very dangerous position, because anything that happens to that person now happens to what it is that you gave them. There are also tax problems associated with it, and it's a loss of control.
Yeah, and along the lines of tax problems,
potential tax problems.
Yeah, and this could be most of the different types of property that have any kind of basis. Your stock accounts, your house, your farmland, your cottage, anything that you transfer over to these kids, if those things have gone up in value over the time that you've owned them, and some of these things you've probably owned for a long period of time and have gone up in value. Well, the big issue is when you transfer them as a gift to these children, your children step in and have this cost basis, which is your original basis in these properties, which can mean that when these things get sold later, they can pay an enormous tax that could have been completely avoided. They can pay significant capital gains taxes, potentially tens of thousands of dollars, and it was not necessary. The other issue is, even if you want them to hold these things and, hey, if I need something later, make sure you have this available so that you can spend it on me. Well, you might be in a care facility and you're spending a significant amount of money on that care at a time when the kid needs to sell, say, a stock account in order to come up with some money to get you something you might need, whether it's care or not. Well, you would have had a significant tax deduction because of all the unreimbursed medical expenses you're incurring. But your kid does not get that tax deduction on these assets. They're just paying the tax on the sale to get the cash to then spend on you. So that can also be horrendous tax planning. So there are a lot of kind of tax traps when you're doing hey, let's just sign it over to the kids kind of plan.
Gift tax forms, for example.
That's another one.
Very often I have people that come in and talk to me, and they tell me about transfers that they've done previously, and the amount that they are. I ask, well, did anybody file a gift tax return when this happened, indicating that you're telling the government that you gifted a certain amount? And usually the response I get is, what's a gift tax return? So I have to assume that one probably wasn't filed as a result. I mean, there isn't always a particular penalty as a result of that, but it's something that going forward can have a big impact on people.
Yeah. So, and we could go on and on this particular myth right here. Just the pitfalls of transferring assets directly. We could do whole classes just on that. But hopefully, we've given enough of a taste of some of the problems just to trigger maybe this isn't the best way to do it in your minds.
And not everybody likes to hear us go on and on about taxes, I suppose.
Well, this next one is of personal interest to you. I know I hear this, I know you hear this constantly, but hey, I should disinherit my child who has a disability because I don't want to disrupt their benefits. And I heard that's just the best way to do it.
I'm always a bit saddened when I hear people repeat this. The idea of disinheriting a child that has a disability or a child with special needs as the way of protecting them from having any sort of money or asset going into their name, interfering with benefits that they may be on or receiving, or especially if they're reliant on them. It is, I think, a very outdated way of looking at it. There are a variety of options that we have right now in terms of planning for an individual that has a disability, whether it's a child or another loved one, whether it's somebody young or an older person. You want to make sure that you are including them to whatever extent you want to. They don't have to be treated differently under your plan. They don't have to be given less or given specific assets or disinherited entirely. The idea of gifting it to or leaving it to another child in the hope that they then use it for the benefit of the one that has the disability is also a very common myth that I hear, or recommendation I hear regarding planning for special needs. Any individual that has a disability, you have options regarding how assets are passed to them so that they can be considered part of what's available to provide for them, but not what's counted for eligibility purposes when it comes to programs or benefits that they may need. I know that there's a lot of concern on the part of the person if they have a particular routine or a particular person that they're working with, that they don't want that disrupted. But you should really be talking to somebody that does planning, specifically special needs planning, to ensure that whatever inheritance you want to leave to this person, you're able to do so in a way that's safe. But the idea of disinheriting them entirely is just completely unnecessary, and it's an outdated way to approach the situation. Make sure that you're talking to somebody that practices in this area.
All right, another one that comes up a lot is, okay, if I do a trust-based plan, I don't have to fund it, meaning I don't have to put my assets in there. It'll somehow just work on its own. That one is one of the biggest problems. And I think part of it is, I don't know, it sort of stems from our industry because as lawyers, there's been too much focus on the documents themselves and not enough focus or education to the community at large on properly using the documents. So as we were talking about earlier, people do a trust with a pour over will and then think, okay, I have this trust, I'm going to be out of probate and my stuff is going to go in there because my will says so. But as Sarah was saying before, a will is basically a set of instructions to the probate court. So you're going to be in probate if you're relying on that to put the assets into the trust. And so it's incredibly important and can have tax ramifications also to coordinate whatever it is you own with the trust that you have, or even if you're doing a will-based plan, the will that you have, so that the terms of your plan properly control the assets that you have. And a lot of times we see an attorney's office maybe did a trust, maybe did a very nice trust, but then just sent out a letter to the client that basically says, hey, make sure you fund all of your assets into this trust or else this thing's not going to work the way you'd hoped. And we see a lot of frustration because invariably, when we're reviewing a plan like that, there are at least a few assets that never got properly coordinated because either the client didn't understand the importance of it. They thought, oh, I got all my wishes down here, I'm all set to go. Or they ran into roadblocks realizing, oh, geez, there's more to be done in coordinating this stuff. And so they've kind of just given up on, changing all the different beneficiary designations or titling the accounts to make sure this thing works. But the end result is that your plan doesn't work the way you hoped. And again, remember, your plan governs everything you ever accumulated over your entire life. And so it's critical. This isn't like a small mistake or a small problem. This is making sure that your loved ones are taken care of in the manner that you wish with everything that you've ever owned. And so It's just not to be overlooked. It is a critical step in the estate planning, which is why, in our office, we work on all of the funding with the client to make sure that when we're done with the planning process, this thing is set up in a way that it's actually going to work. Because, problems after the fact, I don't want to be saying, oh, geez, we told you to fund, so you didn't do it. Sorry, family.
It's also one of the things that we are always sure to review with the client when they come in for their planning, walking through what it is that they own and what it is that they're at that point trying to make sure gets funneled through whatever plan they're using, whether it's a will or a trust. So we walk through what accounts have you opened, what property have you purchased, what have you sold, and make sure that their assets continue to be aligned with the plan that we put together for them. So you want to make sure that this is an ongoing effort that you're making to ensure your assets are funneled through the plan that you have.
Because your assets can change over time, and that means you got to make sure that that stuff stays coordinated.
Mm-hmm.
All right, another kind of long-term care one that we get a lot is, what's that amount of money that you can give to your kids to make sure that you don't have to tell anybody about it, and so then it's safe from going to the nursing home? What's that annual amount? You can give people something or other, and we get a question along those lines all the time. So how does that actually work?
Unfortunately, I mean, this kind of goes back to what I was talking about earlier with gift tax returns. So where this stems from is the amount that you're able to gift to another person without having to file a gift tax return reporting the fact that you've gifted this amount. And it changes over time. So somehow that has gotten connected to elder law and Medicaid planning. So planning around the cost of long-term care, that the gift tax requirement has absolutely nothing to do with nursing homes and long-term care planning. So just because you are able to gift up to a certain amount or up to a certain value without being obligated to file a gift tax return doesn't mean that means that you can gift money to a person and that's okay for nursing home planning as well. There is no amount that you're allowed to gift to another person and have it be overlooked or ignored by Medicaid or nursing home planning related efforts. So the gift tax requirements and the elder law planning, two very different things. The rules of one do not apply to the rules of the other necessarily. And this is one that we hear consistently. So if you're talking about gifting for reporting requirements for the IRS, there are certain amounts that you're able to gift without having to file.
And that amount, by the way, is $15,000 per person.
Right now. But that is inapplicable to planning around nursing homes. There's no amount you're able to gift to another person if an individual is in need of care and you're looking at programs to help offset the costs of that ongoing care.
Yep, you'd have to report any amounts. Okay, another one, and this is also kind of around long-term care. Hey, I've got my assets in a revocable trust. I did a revocable trust back in 2005. Does that give me any protection from the costs of nursing home if me or my spouse go into a nursing home?
That's actually a bit more of a complicated myth than maybe some of the other ones that we've talked about. A revocable trust, when you have things in them, they're still countable for eligibility purposes. So if you own things in a revocable trust and the individual that owns it is in need of care transitions and they're looking for assistance in paying for care, the assets that are owned in a revocable trust are counted for that purpose. So there are other types of trusts that you can use for planning where those assets are not counted, but for a revocable trust, it is counted for long-term care purposes. There are some special considerations with older trusts and estate recovery, but that has nothing to do with eligibility. And I think that's where some of this confusion ends up coming in. But if you have a revocable trust and you own property through a revocable trust, that will still be available for paying for care if you or a spouse need care.
Yeah, and sometimes I explain this to my clients with, okay, there's what can we have and qualify for the assistance? And the other side of it is what can the state have after you've passed away if they've provided assistance? What can they get out of the estate? What can the state get out of the estate? And revocable trusts that were created prior to August 1st of 2014 leftovers might be safe from the state after you die, but they didn't help you qualify to begin with. All of those assets would be countable, and you still have to be financially eligible. So doesn't help with qualification, might help with estate recovery after you die.
Mm-hmm.
Okay. Another big one that we get is, oh, so I have life insurance, and so there's no estate tax to the life insurance. There's no tax ramifications to having life insurance. How's that one work?
Well, it's the idea of it being a particular asset, having a blanket rule about whether or not it's subject to estate taxes. You're just sort of looking at it the wrong way. Estate taxes are applicable to the balance of your estate at the time that you passed away. So what you owned at the time that you passed. Life insurance tends to be have a value as part of it, but where it pays and how you've structured how you own that product is what dictates whether or not it's part of your taxable estate, or the amount that adds up to create your taxable estate at the time that you've passed away.
So ownership of the policy is going to dictate whether or not it's includable in your estate. And then how the premiums were paid can dictate whether or not, because in some rare instances, life insurance proceeds can actually be taxable. For the vast majority of people, if they're just personally paying life insurance premiums, you're not going to have, it's going to be tax-free money that goes to the beneficiary. But if you have a potentially taxable estate, that's essentially where you probably really want to look at the option of using an irrevocable life insurance trust to hold that, because there's ways to make sure that the proceeds from the death benefit, when they pay out, are not includable in the person's taxable estate. So we don't then have to worry potentially about that up to 40% tax that I was talking about earlier. All right, I think we got time for maybe one more. This one can be a struggle to explain to clients. Sometimes they'll say, well, my situation hasn't changed very much since the time I did my plan. Hey, I did my plan 15 years ago, and well, everybody's still alive. So why would I need to update anything in my estate plan? And a couple of sessions earlier, when we were talking about kind of changes over time, we provided as one of our handouts roughly about 20 different very substantial law changes that have happened over the last, say, 25 years or so. And so even if somebody's situation personally hasn't changed a whole lot, and you still have the same beneficiaries, and even if their situations haven't changed a whole lot, even if everybody's living in the same, houses and still is in good health, and you still want the same proportions to go to different people, that doesn't necessarily mean your plan is working appropriately. And again, that's because there has been numerous law changes over the years. Very significant things like, how one from here in 2020 that just became law now is how taxes work for inherited IRA accounts. The timetable for withdrawal has completely changed, which might mean that the estate plan should also completely change to mirror that and get the best results. There's been changes in healthcare laws, trust laws, powers of attorney. I mean, just numerous things that are going to affect a huge number of people. The majority of anybody doing an estate plan have occurred over the last 25 years or so. And so if it's been a while since you've done your plan, it's very important that even if your intent hasn't changed, that your plan is at least reviewed to see, is it working optimally?
You also have to remember that the laws change both at the state level and at the federal level. So there are a variety of things that really do apply to your planning. What we want you to be is informed so that you're making decisions based on your circumstances. And that can only happen if you're taking a look at what your planning is, if you have a current plan, to ensure that what you have is being guided the way that you want.
Mm-hmm. So I think we're about out of time. So hopefully everybody found this to be a useful exercise. We have time for at least one question, I guess. Does a long-term care account need to be named with that person's trust name similar to a checking account? It's a little unclear from the question what a long-term care account is meant to be. There's no technical legal term for long-term care account. I suppose they might be meaning that
I think it's maybe long-term care insurance is maybe what they're talking about. Yes.
Long-term care insurance.
Yes.
Okay.
When I saw Romeo, so I'm assuming that's a reference to Romeo Robbie, who works quite a bit in long-term care insurance. He has a bit of a unique name. A person's long-term care insurance, depending on what kind of product you have, there are hybrid policies that are both have a benefit that can be used to pay for long-term care. If the person doesn't end up needing care, then it has a death benefit on the policy that pays out to the estate. So if you're using a product like that, it would be a good idea to ensure that the death benefit on the policy, if it isn't used for long-term care, is directed, if the person has a trust, through their trust. So having the trust named as the beneficiary on the policy at the time of the person's passing, if there's value left in the policy, absolutely, it would be a good idea to have it going through your trust if that's where you're intending that money to go.
Yeah, and another consideration would be if you have long-term care insurance, whether or not it's a indemnity policy or a reimbursement policy, because that can also dictate how you want the ownership to potentially go. An indemnity policy would be, oh, okay, if you fit these criteria, the policy will start paying out. A reimbursement policy would be like, okay, if you fit the criteria and you show unreimbursed medical expenses, then they'll pay out for up to certain amounts there. And you can actually make different ownership decisions. It's hard to say any kind of blanket, this is what anybody in particular should do without a whole bunch of facts and circumstances where you make an informed decision. But you can actually change where you might want to have the ownership so that sometimes when you have an indemnity policy, it might be better that the insured is not actually the owner of that policy in some circumstances, whether it's maybe the kids or a trust or something like that. But that's a pretty situation specific. So I'm not sure if we answered the question.
We did.
We got to thank you there. So hopefully they found that useful.
So some of the drawbacks of trying to do electronic presentations are the inability to be as responsive or to ask follow-up questions. So
yeah, to make sure we're actually asking or answering what people are asking.
Thank you for the patience. Don't forget about the download that's going to be available, the MIST that we just went through. Our next seminar is going to be this time next week, basically, same on Wednesday at noon.
Yep, Wednesday, May 13th.
Yes, and we're going to be talking about mistakes again. This time it's going to be specific to caregiving. So we see a lot of things when it comes to long-term care. If a person is getting care, especially from a family member or friend, what are some of the biggest mistakes that we see in that regard?
Yeah, and some of those mistakes can be really problematic and cause widespread other issues. So hopefully a lot of people are interested in that one. So thank you for taking your time. I hope you found this to be a useful exercise. Again, if anything comes up in these sessions where you find that it really applies to you and you need to dig deeper with an attorney, you can feel free to contact our office to have an initial consultation. And everybody stay safe, and we hope you stay healthy. All right, take care. Thanks for your time.
Bye.